Recording. All right, so welcome back to Navigating Senior Care with Stella. I'm here with Brandon Garcia, and Brandon has worked in the Superior Court in the probate department, helping families with conservatorships. He is a senior consultant with Pathway Senior Solutions, and we're going to go over what is conservatorship. Do you need it? Do you really need one, and how much it is? And we're just going to go over this and just go over to see if you need that. If you have any questions, you'll be able to comment, and should be able to get back to you. You know, after you leave the comment. All right, Brandon, how are you?
Hey, Stella, doing really good. Thanks
Good,
for
good.
thank you for bringing me on to your podcast. This is fun.
Okay. Yeah. So let's just jump right into it because I don't trying to just get this information out to people.
Yeah.
So
Well, I'll tell you what.
can you tell us?
Let me give you a little bit of my background.
Okay.
Your introduction was great. So yeah, I worked for the Superior Court for about 20 years. I handled cases involving conservatorships, folks that have lost their mental capacity, and so I did that. So folks who had dementia, strokes, brain injuries. I saw the whole gamut. Mental illness. Also worked with the folks who had developmental disabilities, and also the minors who needed guardianships. So, but I spent a little bit of time in guardianships. Most of my work was in working with the seniors. So loved it. My title was court investigator, and just had a great time doing what I did. So I realized, hey, I'd like to start my own practice, and so that's what led to Pathway Senior Solutions. So we're a consulting firm. I work with seniors and their families to help, help them through challenges of retirement, whether it be financial, placement, community resourcing, or any kind of legal advocacy that doesn't require a law degree. So I've been doing this for a while, and I really enjoy, again, working with the senior population. So.
Great. So can you tell us what is a conservatorship?
Good question. What is a conservatorship? So, I want to make this as clear as possible because I know there's some confusion, and I get that question a lot. What exactly is a conservatorship? So I think the best way to explain it is generally people do estate planning, and in that estate plan, there are powers of attorney that the individual can have somebody make decisions for them should they lose capacity. And also after they pass, they have somebody who can distribute their wealth and their assets, right? So you have a power of attorney, and then you also have what they call a healthcare directive. So a conservatorship is actually, it's really a process, and it's the process that's taken when somebody doesn't have those, those vehicles in place. So if they don't have a power of attorney over their finances, they would need to petition the court for a conservatorship of the estate. If they did not have a healthcare directive in place, more than likely they're going to need a conservatorship of the person with medical powers, because if something happens to that individual and they end up in an emergency room, or they end up in a bad situation, with the bank, or, financial fraud and so forth, nobody's going to be able to make the decisions for them if they don't have something legally in place for that person to make decisions for that individual who's lost the capacity to make the decisions for themselves. So in summary, it's basically a vehicle where the court will appoint somebody to make financial and medical decisions over the other person. We call it the conservatee, who has lost their mental capacity to make decisions for themselves. So, yeah.
Okay.
And there's actually different levels of conservatorship. There's the conservatorship of the person. And again, as I mentioned before, that generally is making decisions regarding personal care, placement, where they're going to live. And usually the court will ask for the decision maker to have medical powers, which will give them the authority to make medical decisions. And then there's the conservatorship of the finances, the estate, and the conservatorship of the estate will give the individual the authority to do things like banking, pay bills, enter into contracts, be able to talk to creditors, as well as if an individual needs to go into like a nursing facility and they need to sign a contract, they also have that authority to do that. So, and you can either get one of those as needed, or you can get two. So what I mean by that is it can be either conservatorship of the person or conservatorship of the estate, or it could be both, conservatorship of the person and the estate. And it just depends on the individual circumstances. So, yeah.
So to get one of those, do you have to be a family member, or is that when there's no family, they get a conservatorship versus a POA?
Yeah. So most cases that I worked on, it was a family member. It could be an adult son or daughter. They have to be over the age of 18. And the other part of it is it has to be somebody who's reliable and has, a fairly decent background, right? So it's a process because they want to make sure that the individual who is going to act as a conservator is appropriate. So it could be a family member, it could be a private fiduciary, and it can also be a state agency. So out here in California, we have an agency called the Public Guardian. And so the Public Guardian is like a county agency, and they would take on an individual who's lost capacity. They would act as their conservator. So,
okay.
But yeah. So,
all right, makes sense. Does it cost to get a conservatorship done? And like, how long does it last? Do you have to do it every year, or is it the lifetime of the person, or how does that work?
Yeah, so there is a cost, and cost will vary between, depending on the county, right? I can give you a breakdown generally what some of the costs an individual would incur. So if you have a family member that needs a conservatorship, they would have to petition the court, complete the paperwork, and then there would be like a filing fee. What that fee is gonna depend on the court itself. They determine their own filing fee. So I know where I worked at, the county that I worked in, I believe the filing fee was somewhere between $250 and $500.
Okay.
Yeah. Now there's also every court should have a court investigator who will go out and they will investigate the case for the judge. And their job is basically to make sure that a conservatorship is truly needed, that it's appropriate, and that the person that's petitioning the court is really an appropriate, safe individual that can make decisions for that family member or friend or whoever it is. So, and the whole idea behind that is to prevent like a complete stranger, taking conservatorship and then making it a worse situation than what it already is, right? So that's why you have a court investigator involved, and usually the court will charge a fee for the court investigator. So you have the filing fee, and then you have the court investigator fee, and then any other fees after that. If you're working with an attorney, a probate estate attorney who specializes in conservatorship, that will be an expense as well. So I've worked with attorneys that charge to get it started. It would be anywhere from $5,000 to $7,000 just to get it started, right? And that would include the filing fees. That would include, that would not include the court investigation. It would include the filing fee. But each attorney is different, how they operate. The cost will vary. So if you were to ask me, without an attorney, to start a conservatorship, it's probably going to cost anywhere from $1,000 to maybe $2,000. And if the individual cannot afford those fees, they can always go to the court and ask for a waiver. So most, if not all, courts in the United States allow for a fee waiver program. And here's the other thing too. The person that's being conserved, typically the petitioner can ask the court for the fees to be paid out of the estate of the individual who's being conserved. So there may be an initial out-of-pocket expense, but then they can get reimbursed by approval of the court. And they would get reimbursed from the estate itself. And again, it just depends on the amount of the estate. If there's really nothing there, then they're going to have to, eat the cost or petition for a fee waiver. So, and then you had asked me about how long a conservatorship lasts. So it does last throughout the lifetime of the individual. And I have seen some cases, and it's very rare, but there have been some cases where an individual would be placed on a conservatorship with the court, and then maybe maybe 5 years later, it's found that they have enough capacity to appoint like a power of attorney. And those cases are very rare, but me personally, I worked on a case where there was a lady who had been on a conservatorship for at least 10 years. She was placed on the conservatorship because she had some criminal charges. And the judge from the criminal court, and because she was like 81, 82 years old, the judge from the criminal court, they settled on an agreement to allow for a conservatorship to be in place to be able to manage or keep the lady under control, because she had a really bad anger problem and she had violations of her restraining order. And to prevent her from going to prison, so it was a really interesting case. The court agreed to a conservatorship of the estate, and I happened to be the court investigator reviewing her case, and she said, I'm pretty much done with my probation terms, and I want to come off my conservatorship. And me being the court investigator, I have to be fair about it. So what I did is I appointed her an attorney, and lo and behold, about a year and a half later, she was able to get off the conservatorship. So it was a successful case. It was a very challenging case, to say the least. But I think the court did make a good decision in that circumstances, and she was able to kind of live her life more independently. So, but yeah, so it can be terminated early, or when the person passes, that's when the conservatorship will end. So it's throughout the lifetime of the individual.
Okay.
So, yeah. So.
Okay. So I guess when there's a conservator in charge of somebody, can they like override family members' decisions? I mean, they're like totally in control, or can other family members can make decisions for them?
Well, in an ideal world, this is how conservatorships really, I think, should operate. One individual is appointed by the court to make the ultimate and final decision, right? So let's give an example where let's just say the person's on life support, right? That's a very, very sensitive decision. Now, let's just say that the person didn't have any special like DNR orders in place. So the person that's appointed conservator is really the one that would make the ultimate decision. But ideally, it's the responsibility of that conservator to really consult with all the family members about what's happening and what the family's thoughts are on it. And based on all that information, the conservator should make the decision whether to end life support or not, right? So that's just one example. Other examples would be like, should we sell mom's home? There should be some buy-in from family members, if there are family members. Now, that I say in an ideal world, in the real world, what I witnessed many times was you have one conservator and you got siblings that just don't agree with each other. And so it makes the job of a conservator a little bit harder because there's just all this influx of fighting and, disagreement and so forth. And this is where I think, personally, I think the beauty of the court system and the players involved can really step in and help this family come to a very rational decision that's going to be in the best interest of the conservatee. So, yeah, so it's not like somebody has full authority and they're just going to make decisions left and right and nobody's going to have any say. That's the worst case scenario for a conservatorship. The best case scenario is when there is family involvement and even involvement of the conservatee. Even that individual can, if they can speak and make some sort of decision, that person could express what their wishes are. They have the right to object. They have the right to say no. They have the right to inquire about the decisions. And usually in those cases, they're given a court-appointed attorney that will help the conservatee or will represent the conservatee when there's conflict. So, or when the conservatee doesn't want the house to be sold, or they don't want an account to be liquidated or something like that. So there are protections in place for that person who's lost capacity. They lose the right to make their own decision, but they don't lose the right to have input, right? There are certain rights that they have protected. And usually the attorney that represents the conservatee will help guide that conversation. So, yeah.
Okay. So I know you said, with lawyers, the cost, but can family members do this conservatorship by themselves? Like can they manage
Yeah.
themselves?
Yeah. Um, I would say, and I'm just speaking for kind of like California, and this is probably a rough statistic, but I would say maybe 65% of the cases that come to the court are folks who have hired an attorney, right? So the other 35% or 40% are folks that they don't have an attorney representing them. What's good about the court system is every courthouse should have sort of like a guideline where individuals can go to the website or go to the court and ask, what's the process? How do I do the filing? Where do I go to get certain signatures? Who needs to be notified? All that, because it's not just like a one paper application and then you submit it and then the judge says, yeah, sure, why not? You got to get doctors input. You've got to get family input. They have to be noticed that there is a conservatorship hearing. The proposed conservatee, the elder person or the person that lost capacity, they have to be notified. There's just a whole legal process, they call it due process, that needs to take place before the case can actually be heard by the judge. And even the court investigator has to be involved in that process as well. And they file their report. So it can be a daunting experience. And that's why a lot of people do choose to work with an attorney. But there are cases where, some people are very savvy and they can manage it on their own. Some people may not have the means to afford an attorney, and so they do the paperwork on their own. I think by law and in California, all courthouses are required to have some sort of self-help program. So they can go to the self-help office and get guidance there. There's a lot of free advocacy programs that help litigants who are not represented to be able to guide them through how to file for conservatorship. And then you got individuals like myself who are willing to kind of coach them through that process and make sure that their paperwork is right and make sure that they're doing the right steps to get to the hearing part. So so there's a lot of help out there. It is a cost factor if you do decide to use an attorney. And again, it just depends on how complicated the case might be. It also depends on the financial situation of both the petitioner and the conservatee. If there's multiple parties involved, an attorney would probably be advisable. I've seen very good conservatorship cases and I've seen very ugly ones. And the ugly ones, they all have attorneys, and the cost factors just go way up. So yeah, so sometimes you're forced to get an attorney, and sometimes that's unfortunate. So yeah.
Okay. Well, yeah, for Travis County, you know, I looked it up and it is like you go to the Travis County probate court and you should be able to get all the instructions there too. So I did just look that up. But
Yeah.
I guess the last question for you would just be like, what would be like the biggest mistake that you've seen with families who are doing these conservatorships? Like, what would be like the main issue that they run into, or
I wish I could say there was just one.
oh, there's a whole lot. Okay.
Because part of my job is to kind of be the referee, and hey, you guys aren't doing your job here. But you know, a lot of times, I would say this, and maybe this is a good way to kind of couch it. Usually mistakes are made when the individual is not really informed, or they're not seeking the information. And so they're operating in a certain fashion, thinking that everything's okay. It's okay for me to do this. And then they go to court, because we have to review those cases. And then when the court investigator goes out, or it might not be a court investigator, it might be a department that does investigations for probate matters. But when that happens, then they find out, wait a second, this is wrong. You know, you can't be doing this. And so that's kind of the number one reason why people who have conservatorship, meaning the people that are making decisions for the person that lost capacity, it's probably because they're uninformed, or they have some kind of ulterior negative motives to take advantage of the individual. Some of the common mistakes initially that I see, or that I saw in the court, was a lot of it was just paperwork issues, not getting the notices out on time, not really understanding their role as a conservator, could create problems for the case. Another mistake that I've seen throughout the case is the conservator. We all know this case, the Britney Spears case, right? In my professional judicial kind of opinion, I believe the conservator was given too much authority and too much overreach. I don't know the specific details of that case, but just by looking at it in general, she probably needed a conservatorship, but she also had the right to have some freedoms in place. And I think the conservator was kind of overreaching their authority that was given to them. It was tragic, because I felt like some of it, was probably unnecessary. So there's also that factor, wanting too much control. Another common mistake is, this was actually common. They would sell property without necessarily notifying or letting the court know that the property was going to be sold. That was a huge one. I've seen conservators get literally reamed by the judge for doing things like that.
Yeah.
So yeah. So a lot of mistakes. A lot of them are innocent mistakes. The conservator, didn't really understand. Maybe they're not represented by an attorney. And so it's just a matter of going back and correcting it. But there are a good handful of cases where mistakes were made intentionally to kind of take advantage of of that person, who lost capacity. So, and yours truly got to see it all. Day after day for 20 years.
Well, all right.
So
I mean, that's a lot of information you shared with us, and I thank you for that.
thank you.
This is Brandon Garcia. He is in California, so if you need to reach out and get some information about this, his number is right there on the screen. He is um, with the Pathway Senior Solutions. His website is seniorpathwaygroup.com if you want to just reach out to him. I will add some resources to my resource page for Travis County for the conservatorship, and just to go over this again of whatever everything that he has mentioned. You can see that at Stella Herrera, Stella Williams tx.com resource page. I will include it in the link somewhere so it'll be easily found. But I want to thank you so much, Brandon, for sharing all your information.
Sure. Real quickly, if any of your viewers need help with conservatorship cases, I'm in California, but I am able to guide them through the process and work with them even in Texas. So I'm not an attorney, so a lot of the things I can help them with is like non-legal services, and I'd be more than happy to do that for them. So yeah.
Great. So again, his number is right there on the screen. Reach out to him if you need some help. Reach out to me. All right. Well, thank you, Brandon.
Thank you. Have a great day. Thanks for inviting me on this on your podcast. It was fun.
All right. Thank you.
Okay. We'll see you.
Bye. I don't